Hello, everyone. Welcome. Thank you for coming. The panel is facing headwinds with 2 baseball games and the Democratic debate tonight. So we appreciate everyone squeezing us in, and we're going to try to be sure to end on time. So people who want to get to the second baseball game, the NL game, or to the debate will not be too inconvenienced. I think that the activation of Title III lawsuits under Helms-Burton this year is really going to end up being one of the more interesting and significant international law, at least private international law developments of the year. And so I'm really happy that the Society has decided to have a couple of events on it. This is the first of at least 2 events. This one was organized by the Dispute Resolution and Latin America interest groups. And then we're going to have another panel at the University of Miami as part of a conference on February 14th and 15th that's being organized by the International Economic Law interest group. As Wes said, we have a full panel, I think a very strong panel today. It includes Professor Paul Stephan from the University of Virginia, and then a distinguished group of practitioners. We have next to me David Barron from Crowell Moring, Jason Poblete from a boutique law firm, then Gretel, I'm drawing a blank on your name, Echarte from Mayor Brown, and Steve Davidson from Steptoe and Johnson. And so we're going to try and organize today in a series of short discussion and try and keep it lively and end our discussion by 7:15 and then bring in Q&A at the end there. So with that, we're going to start with Jason, who is going to briefly tell us why we have this law and what it's all about.
How much time do I have?
2 minutes.
Right. Well, in the brief time I have, I'm just going to give an overview of how it developed and how we got here. I started on this back in the 90s, before this was even law. I grew up in the diaspora in Miami, and I had come to Washington in 92 when they had just passed the Cuban Democracy Act, which was a precursor to Helms-Burton. And if you take a look at what the common thread was then to what happened in 96. Remember, keep in mind, this was at the end of the Cold War, and there had not been a policy readjustment yet on Cuba. And that was the very first one, the Cuban Democracy Act. It opened up telecom and allowed us to sell telecom services to Cuba. But on the issue of property, which was the reason why we had the embargo to begin with, it was generally silent. So we never got to the heart of the real conflict with Cuba, which I believe has always been the property claims issue. Even when I was down growing up in Florida and dealing with the Cuba issue on the political side, you never had that fulsome discussion that I think you had to have to actually move product on U.S. policy on Cuba, which was always property. I'm skipping over a lot, but I'm going to mention briefly a Nicaragua issue, the Helms-Gonzalez bill, which was a law that was passed that was the precursor, was in 94, that basically dealt with property disputes in Nicaragua, and it allowed Nicaraguans who lost property during the revolution to have a mechanism to deal with their property disputes. And Senator Helms and Congressman Gonzalez were conditioning foreign aid. It's kind of a backdoor to the Hickenlooper, which I'm not going to get into now. But a lot of the ideas that came from that exercise kind of bled into Helms-Burton 2 years later. And Helms-Burton was the first time it really got onto the issue of property, which is really the biggest dispute we have with Cuba right now. $1.6 billion in certified claims. If you add interest to that, it's about $8 to $10 billion. And Helms-Burton at first, again, keep in mind, this is the end of the Cold War, where now everything's plugging along, Eastern Europe's rebuilding, but Cuba was still stuck there. The Cubans would not settle the claims. These claims have been pending since the 1960s. Cuba could have avoided Helms-Burton. They could have paid the claims. We had a process in place that went through the Justice Department, the Foreign Claims Settlement Commission. If you look at it from a pure economic standpoint, they could have avoided probably a lot of Helms-Burton if they had settled the claims years ago, decades ago, but they didn't. because they were openly encouraging trafficking in property that they knew was stolen. Now, we can disagree about why Cuba does that. I believe Cuba does not want to settle these claims, even though the Cuban ambassador has told me on multiple occasions they want to settle the claims, but they haven't. They keep kicking the can. So Helms-Burton happens in '96. And frankly, if it hadn't been for the shoot down that resulted in the death of 4 Americans and a U.S. legal permanent resident, this law may have never happened. I mean, this law was filibustered twice in the Congress over these 2 sections of Helms-Burton, Title III and Title IV. But when Cuba shot down those two planes, I'm not going to get too much into that. I think it created political momentum that gave enough votes to overcome the filibuster, and President Clinton and the Republican Congress were able to move product. And here we have the law today. 4 quick points, and then I'll just move on. My next panel is 1. I think it's important to keep in mind that there's no right, legal or moral, to profit from stolen property. The international legal system back then and still does today lack an effective remedy, and that's in the statute, and I still think that's the case today. Cuba was and is still encouraging trafficking in property. And I think after 20 years of effectively lobbying Washington to keep Title III at bay, because they have lobbied, they've been very successful working through Canadians, Europeans, and some American companies to keep Title III at bay. We now have an opportunity to finally get to the nub of Helms-Burton and why it's there to begin with, which is to settle the claims. Whether or not the lawsuits will do that, I don't know, but it is a new mechanism that we have. And finally, international legal norms allow it. I know there'll be some discussion about that, but I do believe that under customary international law, we have the right to provide an avenue for our citizens to redress their claims in court. And as Senator Coverdell said when Helms-Burton was passed, it's a new standard. It's going to impact beyond Cuba, I believe, if it's done correctly. And it's unique to the American system. There are some significant legal issues that I think will be sorted out in court, but that's the way the law was drafted. It was drafted vague for that reason. And I think that some of these cases, there are about 20 of them right now, we're going to see some of these issues fleshed out.
Thanks, Jason. We're now going to turn the floor over to David to get a summary of what the statute and particularly the litigation provisions of it have to say.
So I'm going to try and be brief because I think most people probably know what we're talking about, but just to set the table in case some don't. Helms-Burton, as it was passed in 1996 following the shoot down of the Brothers to the Rescue, really followed a series of bills and discussions that were negotiated actually in the summer of 1995, then put on the table, and that came back and kind of came roaring back to life as the United States needed to respond to the shoot down to the Brothers to the Rescue. And for present purposes, there are really 2 sections, Title III and Title IV of Helms-Burton, that I think are most in play and alive since May 2nd of this year, when President Trump essentially allowed the suspension of Helms-Burton, which had been suspended for consecutive 6-month periods since 1996 by presidents of both parties, Republican and Democrat, to come into effect and force. The statute was signed into law by President Clinton back in 1996. It was allowed to come into force, but it was immediately suspended for purposes of Title III anyway, which is the provision that essentially says that any person who traffics in property which was confiscated by the Cuban government on or after January 1st, 1959, shall be liable to any United States national who owns the claim to such property for money damages in an amount equal to, and then there's some formulas that basically say what the property was worth at the time that it was confiscated, what the property is worth today, or what the Foreign Claims Settlement Commission sitting as special master determines it to be. And then there's some troubling provisions on the damages as well. The definition of trafficking is probably worth just a little bit of mention. It's extremely broad by definition and intention. A person traffics in confiscated property if that person knowingly and intentionally sells, transfers, distributes, dispenses, brokers, manages, or otherwise disposes of confiscated property, or purchases, leases, receives, possesses, obtains control, manages, uses, or otherwise acquires or holds an interest in confiscated property, engages in a commercial activity using or otherwise benefiting from that confiscated property. By definition, the definition of trafficking is intended to be extremely broad in order to give U.S. nationals, and that includes both nationals who were nationals at the time of confiscation and who had their property claims certified by the Foreign Claims Settlement Commission, and persons who were Cuban, frankly, at the time that their property was confiscated, but who came to the United States and subsequently became United States citizens after the confiscation, but before Helms-Burton entered into force back in 1996. Just 2 more minutes on a couple of the practical issues that I see on plaintiff's side, dealing with some of my clients and looking at some of the claims and some of the things that I think people look to and that help to explain some of what we've seen in kind of the slow warm-up in terms of the filing of cases, and now some of the more recent, some would call it a tidal wave or an explosion, or maybe not, but we've seen kind of a burst of cases start to be filed. The first is that when you are looking at a claim and you are looking at the potential to bring a Helms-Burton action or to consider bringing a Helms-Burton action, you're really looking for 2 things, or 3. The first is, can you prove your claim? The second is, can you prove that the trafficker is subject to U.S. jurisdiction in the United States court, such that it makes sense to try and sue them? And third, whether or not there are assets here. Because, as I suspect we will hear, there are questions about the international enforceability of any Helms-Burton judgment, but that would not necessarily apply within a United States court. One final point, just because it probably ought to be said. Back in 1995, well, let me start with this. Is there anybody here who has studied civil procedure and been to law school within the last 5 years? Okay, 1. So for all of us who went to law school longer than 5 years ago, and you know, I'm old enough that I actually sat in all of those hearings in 1995. Yeah, no, thanks. I appreciate that, Jason. I remember you saying you were here already.
Yeah, I know.
So, back in 1995, when Helms-Burton was drafted in 1996, when it entered into effect, we had a concept of general jurisdiction that said that if you are a foreign corporation or a foreign entity, and you are in the United States with a presence that is essentially continuous and systematic, you can be subjected to general jurisdiction such that exerting jurisdiction over you doesn't violate traditional norms of fair play and substantial justice. Some of you are shuddering as you remember back to first year civil procedure. In 2014, so 5 years ago, the Supreme Court reinterpreted what it means to be subject to general jurisdiction and said that it means to be essentially at home in the jurisdiction, which it then interpreted in a case called Daimler to mean that you needed to either be incorporated in the jurisdiction or have your principal place of business in the jurisdiction. Now, kind of by definition, if you're a foreign corporation, you're not incorporated in the United States in the jurisdiction, otherwise you wouldn't be a foreign corporation. And then almost further by definition, having your principal place of business there. So concepts of jurisdiction have changed between back when we passed Helms-Burton and it entered into force and today. How some of that will be worked out remains to be seen. And with that, I will punt over the rest of my time.
Thanks, David. So what we want to do now is bring Paul into the conversation. We've already heard teed up a little bit the question about whether or not Helms-Burton is consistent with international law. And really the question is, under the international law of jurisdiction, whether the United States has the ability to regulate when third country businesses do trade or investment with Cuba. And Paul's really an expert in the international law of jurisdiction. He recently served as one of the reporters of the Restatement Fourth on Foreign Relations Law on jurisdiction, as well as a overall, I think, coordinating reporter for the whole restatement project.
So thank you. First, I apologize for the way I dress. This is the first time I've ever been in this building without a suit and tie on, but I think my reasons are evident. And I will duck out a little bit early in order to meet my wife and son, and we hope destiny. So I have three general points to make, and I'll make them quickly. One is I'll address the question of whether the enforcement of Title III produces an internationally wrongful act by the United States. And the headline is that reasonable minds can differ, but I think there's a case to be made that the United States is not engaged in an internationally wrongful act. But a reminder that at least it's the position of the Fourth Restatement, and I think that is an accurate summary of where law is right now, that a judgment does not have to be recognized and enforced by another state simply because there's a lawful basis for jurisdiction. International legal violations are a sufficient but not a necessary reason for refusal to enforce a judgment. So I want to decouple that issue. Secondly, more briefly, Helms-Burton as a contribution to the development of human rights law, and then finally Helms-Burton as a contribution to the concept of piercing the veil in international law. So on those 3 points, the claim that the United States is committing an internationally wrongful act by hosting Title III lawsuits is that the United States is prescribing rules of ownership of property with respect to property on the territory of another sovereign state, that the United States is not only seeking remedies for what are arguable violations of international law with respect to its own nationals, where the U.S. position, I think, is on strongest ground, but also seeking to vindicate the rights of U.S. nationals who were not subjected to acts that at the time would have been considered internationally wrongful. And indeed, what injuries they suffered when they were not U.S. nationals, which is a second class of potential Helms-Burton plaintiffs. So what is the defense for the U.S. position? Well, first of all, as to U.S. nationals who suffered what I think fairly can be considered internationally wrongful act on the hands of Cuba in the early 1960s, I think it's a widely recognized basis of international law jurisdiction over a state's own nationals with respect to wrongful acts suffered outside the territory of the state. The case for vindicating the rights of later acquired subjects, people who were not U.S. nationals when they suffered the injury but now are, I think has to rest on passive personality jurisdiction, which is the idea that a state has the right, some right, to vindicate the interests of its nationals, even if the basis of those rights does not rest on international law. And this is a head of jurisdiction that at the time of the third restatement in the 1987 is when it was published. It was developed in the 10 years prior to that. The reporters saw it as controversial, but a growing acceptance, at least as to some categories. And when we revisited that issue over the last 6 or 7 years that we worked on the fourth restatement, we thought that although there is by no means a full consensus either as to the existence of the legitimacy of passive personality jurisdiction or the instances in which it may be asserted to justify state regulation, there is growing acceptance. So it is not a pariah, although it's not yet a favorite child of international law. But I think a case can be made that interests of nationals not grounded on international law can be a basis for the assertion of extraterritorial jurisdiction. And I'll just note the two cases of the Court of Justice of the European Union in the last month, and Facebook and Google, that recognized a non-international law interest on the part of French and Austrian law to impose, in the Google case, worldwide jurisdiction with respect to an Austrian sense of the right of the individual from invasion of privacy, even as to truthful acts. So, just as in effects jurisdiction, the U.S. position, which was an outlier and seen by many as a gross imposition of a hegemon's authority in 1945, by the late 80s had been embraced by the European Union, one could see a development along these lines as well. Now, again, emphasizing the fact that there's an arguable case to be made under international law for these suits does not mean that any state is under any obligation under international law to accept it and recognize and enforce the judgments. There is no obligation under international law, absent a treaty, to recognize or enforce a foreign judicial judgment. So they don't need an argument. They can just refuse to do it. Quickly on the human rights point, the right of aliens to be protected in their property is long-standing, although controversial. But at least the U.S. position has been developed over more than a century, modeled more or less on the U.S. takings clause of the Constitution, of the Fifth Amendment of the Constitution. What is new is merging this with human rights law, which protects subjects against their own state. I am of the view, this is not something everyone agrees with by a long shot, that this concept of human rights law is relatively recent, roughly, I think, crystallizing only with the Helsinki Declaration in 1975. So long past the events of Cuban nationals suffered in the early 60s. But the idea that human rights extends to the protection of property, I think, is a valid claim. The resistance to it is it's old school. It's what John Locke came up with at the end of the 17th century, and he didn't recognize the risk of plutocrats to liberal democracy in the world. Many believe that recognizing a right of property is to recognize the power of the plutocrats, and that's a perversion of the international human rights system. I disagree, but whether I'm right or not, I think you can frame Helms-Burton as a baby step, framed by crass political calculus, but nonetheless a baby step in the direction of recognizing that right. And then finally, and very briefly, this trafficking concept is a very interesting way of piercing the veil. It's converting a in personam right to an in rem right, saying it's about the property rather than the wrongdoer. Now, some would say simply trafficking in the property is itself an independent wrong. The problem I find with that argument is it overlooks that, at least in the locality where the trafficking is occurring, there was no crime. And under international law, as to people who were Cuban nationals at the time, there was no international law violation, however morally objectionable those acts were. But to say that we're going to go after the property rather than at the primary actor who committed the wrongful act is a very interesting development. I do a lot of work on UCOS claims, and now that there are significant arbitral awards, people have been looking around, casting longful glances at people like Rosneft, which acquired all of the UCOS assets in the Russian government's expropriation. And HelmsBurton is a bit of a template for things that may develop down the line if we go in this direction. Thank you.
Well, thanks, Paul. What I'd like to do is just engage in a little colloquy and try and bring out a couple of the important points that I think you raised for our audience. And so first, if I heard you correctly, I think where you come out on the question of the international law of jurisdiction is that there's a pretty solid argument that Helms-Burton can be justified under passive personality jurisdiction with regard to claimants who were U.S. citizens.
Who are not U.S. citizens.
I thought you said who were U.S. citizens.
are U.S. citizens now.
Yeah, the ones who were U.S. citizens at the time when they suffered the injury.
Yeah.
And that it is a weaker argument for people who were Cuban citizens at the time that they suffered their confiscation. And so I'm wondering, where you come out. Is it for the people who were Cubans? Is it a violation for the United States to assert jurisdiction on behalf of them, or is there some other basis? Given your human rights argument, is it universal jurisdiction, or what? Where would you? How would you advocate for the U.S. position?
Well, I perhaps wasn't completely clear. I think the argument for U.S. jurisdiction with respect to people who were U.S. nationals at the time of the expropriation is very strong.
Okay.
And it doesn't need passive personality. I think that citizenship or subject jurisdiction does the work there. So I think you need passive personality only for the people who were Cuban nationals at the time, but have become U.S. nationals. So they are ours now, and they have an interest in this, even though the origin of the interest was not an act that would have engaged international law at the time of that act, because it was national, and we didn't have this human rights concept that people talk about so much now. So where I come out, now that I hope I've clarified my point, where I come out is that, if, like Ron Bettauer, if I had been in the government in 1996 and advising the government, I'm very interested in Ron's views, but I would have said, you should be very careful about this. You're breaking new ground. I would not say that it's clearly unlawful, and I would say that of some other things going on in 1996 in the United States. Section 1605A of the Sovereign Immunity Act.
Okay.
But
that's the expropriation exception.
No, that's the terrorism.
The terrorism. Right.
Yeah.
Okay.
Yeah, but I would have been very nervous and try to raise concerns. Once it became law, were I in L, where I spent a wonderful year and a half, I would have seen my job as defending it, and I could defend it with a straight face. Where I would come out if I were a judge that had to decide it, I have no idea. But no one would ever want me to be a judge in such a case.
Okay, fair enough. And then, you mentioned the possibility that HelmsBurton may now be starting to be thought of as a precedent for other unresolved expropriation situations, which I think is a really interesting point, not least because, I think one of the oddities about HelmsBurton is it's been around for almost a quarter century now, and there has been no other serious effort that I know of to put into place anything similar, while we have seen a huge uptick in activity through investor-state dispute settlement, mainly, to protect against expropriation. So it's always seemed to me like an outlier that was kind of left behind by even by the U.S., let alone by the international community. And so I'm curious, is it a good precedent? Is it something that should be extended? And in what circumstances should it be extended?
So I would always prefer to see this worked out among states and put into conventional form, to see this done through treaties. So there's legal clarity. There's a certain amount of indeterminacy about the customary international law process that creates legal risk and opportunities for abuse. We can end up in arms races over similar claims, and it's not only the good guys that make these kind of claims. So that is a concern about this. We have seen significant uptick, not just in the United States, although the U.S. has led the way in human rights and anti-terrorism litigation. We haven't seen anything similar in expropriation, but we have seen during the same time period a sea change in the law of anti-corruption, which gets at some of the same problems, abuse of state power. If we just focus in on expropriation, I agree completely. We haven't seen much new development at all. And if anything, with the popular backlash against ISDS around the world, it may be 5 or 10 years before lawyers are making any decent money out of this kind of stuff. I think of having international regulation, one hopes more by conventional than customary processes dealing with what we might call economic abuses. I think that's something that's in our future.
Okay, very interesting. And then one last question for you, and then I'd like to see if anybody else wants to weigh in on the specifically the international law issues we're talking about. But at the risk of offending our audience, why should we care if the U.S. action violates international law? I don't think that, given the clarity of the statute, that the Charming Betsy doctrine would have much impact on the interpretation. I think it's unlikely to be considered a valid defense. So, to what extent do you think that it matters?
Well, are you asking why do I care about international law, or why do I care about this particular piece of international law? I think that
I suppose you could answer it even more broadly. I mean, do you think it matters whether the U.S. is considered to be acting with this statute consistently with international?
So I believe two things. I believe that international law should not be valorized to the point where it becomes a knockdown for any argument. We ought to recognize that many of the things that we call international law are contested, that there's a great deal of variation around the world, and that it's always useful to take a fresh look at things. I also believe that the United States has traditionally played an important role in developing norms and principles that have been useful to the world as a whole. And to the extent that we sacrifice our ability to have that benign impact on the world, I think we're all, it's not just U.S. interests, but I think there's a harm that has a global impact. So I think to the extent that what the U.S. has done can be both defended and cabined, I think that's a useful thing to do.
All right, thanks very much.
Perry, I'd also add on that, this statute also shows that from an international perspective, it can create quite a commotion and a dispute among nations. Not saying whether it's right or wrong, the statute that is, but as you know, many of the countries that would be potentially impacted by Helms-Burton in terms of their citizens or corporations impacted have passed their own statutes, blocking statutes, trying to prevent the applicability of Helms-Burton to their citizens. And it'll be interesting as the litigation develops how that plays out, because these countries have passed laws stating that if you're impacted, if you as a Dutch national or a Canadian or some of the other countries that have passed these, if you're impacted by this, you have the right to sue in our courts, basically to block whatever judgment someone would get in the United States court. So I think in an odd sort of way, it validates the need to have international law in some sense of how this should be done. Because I think how this Helms-Burton plays out will be impacted very much by those kinds of statutes and what other countries do. To date, as far as I know, no one has filed suit in a foreign country to take advantage of those. And a lot of the targets so far are, or at least some of the larger targets, are American companies. So they don't have that ability to do so. But we'll see as the statute unfolds and whether more cases are brought and how that affects it. But I think it's kind of an interesting analog to international law and showing how it's sensible to have a way of doing things.
And could I just jump in with one more point? I should have gotten this out, and I'll try to be very quick. I can think of at least two instances where the U.S. started off regulating sectors that many of our friends and allies thought was producing internationally wrongful effects. One was in competition law starting in the 40s, and the other was the FPCA starting in the 70s. And the U.S., in the case of competition law, spent roughly 40 years in the wilderness, and the FPCA roughly FCPA. We spent roughly 25 years in the wilderness. In both cases, we ended up with international cooperation that I think was driven in part by other countries saying you have to deal with these guys one way or the other. and I think one can argue in those two areas that the outcome we're now in is relatively benign. Cartels really don't do much good for anyone, and although corruption can be weaponized, I think the principle of the corruption is bad, is a good one. And I'm not saying that expropriation will go down the same path. The fact that two good things have happened doesn't mean a third will. But I just want to throw that out there.
Very good. Thank you, Paul. So I'd like to go back now to Steve and bring Gretel into the conversation. And what we're going to hear from these two is, first we're going to hear from Steve about the kinds of claims that have been brought so far under Title III, and from Gretel about the kinds of defenses that have been hinted at least so far.
Thank you. We represent ExxonMobil Corporation in the case that's been brought in the District of Columbia Federal Court, the case in front of Judge Mehta. And as a result of that, and prior to that, I've taken an interest in this statute and can give you a bit of an overview of how things have gone. With respect to our case, I'm not speaking for the client, of course, and I'll confine my matters to matters of public concern and that are in the public domain. As I'll talk about in a moment, the briefing on the Cubans' motions to dismiss has begun, so I can give you a little overview, at least, of the arguments they've made. If you want to hear what we're going to say, you've got to check back in a month or so. But in terms of the cases, it's been, I think, kind of interesting, because I think for people who followed this statute, there was, I think, a sense that once the door was open, that a lot of litigation would ensue. And although there has been a fair amount of litigation, I think I've been surprised by how few lawsuits there have been by certified claimants. There are hundreds of millions of dollars in certified claims that were approved by the Foreign Claims Settlement Commission, most of which have not been filed. I think we might be the only one with a certified claim that's brought a lawsuit. And as I think David said, you don't have to have a certified claim to bring a lawsuit. If you have one, you create certain presumptions in your case, but others can bring them. Their proof levels are perhaps more difficult. But it's interesting because if you look at the list of the register of claims, it's a lot of well-known big companies, some of which are sort of unusual how they ended up with these giant claims, because it's been through corporate acquisitions like Office Staples or Office Max has by far the largest claim, because they, through their predecessors in interest, owned the Cuban Electric Company, which is by far the largest of the certified claims. But to date, there have been, as best I can tell, 20 lawsuits filed, the vast majority of which have been filed in Miami, in the Southern District of Florida. And 4 of them are seeking class action certification. The targets of the suits in Florida are largely what I would call travel-related industries, cruise lines, travel sites, hotels, and the claimants in those cases are not certified claimants. A variety of individuals who have claimed that their property was expropriated and now being used either as a port for the cruise ships or a hotel, or that the travel sites are trafficking in their property because they're using their property is being used for people to book hotels and so on and so forth. There are there's one case, our case filed here in D.C., and then there are the other cases. There's one in Washington State, one in Nevada, one in Delaware. But as I said, I was kind of struck by how few, just one, of the certified claimants have actually filed suit. And I think it might be useful, might be interesting to sort of discuss why we all think that is. My view on that is that I think people are worried about whether they'll be able to recover anything. I mean, I think that's the most fundamental issue. Winning these cases isn't necessarily easy, but I think what's really stopping people from going forward isn't that they're worried about winning and losing so much, as that they're worried about, will we be able to recover? And who are you going to sue? And are you going to sue an entity that will subject your client to potential liability on one of these blocking statutes from a foreign jurisdiction? So I think that has, at least in my view, caused a drag on what I thought was going to be a lot of lawsuits, a lot of litigation activity. In terms of our case, we filed it on the first day we were allowed to, which was May 2nd. As David talked about, the Trump administration did something that none of the predecessors had done, which was allow these private suits to be filed under Title III. And over the course of the year, sort of the ability to do it was sort of squeezed out bit by bit. First, it was just against entities that were on the restricted list. And then eventually, in the middle of April, it was announced that any proper defendant could be sued as of May 2, which is the day we filed our suit here. And the defendants in our suit are Cemex and Cupid, both state-owned entities. Our case, I think, does not have the elements or the problems of the blocking statutes because our defendants are Cuban. All these claims have sort of an interesting kind of Caribbean history to them. Our claims arose from Esso and Standard Oil, corporate predecessors to ExxonMobil, from an oil refinery, a marine terminal, and 117 Esso gas stations that were operated in Cuba and taken over by the Castro government in 1959 and 1960. And my lawyer predecessors prosecuted these claims in front of the Claims Commission and obtained a certified claim of $71 million plus interest as of 1970. And that's the amount of our damages. As David said, there are other damages potentially available here. There's interest, attorney's fees, and treble damages, which are available to those like Exxon who have a certified claim. I was somewhat surprised that the Cuban government decided to defend, and they have entered an appearance. We negotiated an agreement over a briefing schedule. They agreed to accept service, and so service isn't a question here. And recently they filed a motion to dismiss that was based principally on two grounds, saying that there wasn't subject matter jurisdiction because as a foreign sovereign, there wasn't any applicable waiver of foreign sovereign immunity, so that the court here didn't have subject matter jurisdiction. They also claimed a lack of personal jurisdiction. They are claiming that these entities, though admittedly agents and instrumentalities of the government, as per the FSIA parlance, are nonetheless sufficiently separate from the state so that they are considered separate entities, which is potentially an important issue because as a foreign government is not entitled to the protections of the Due Process Clause for personal jurisdiction purposes. What Cuba has alleged in its motion of stating that there isn't personal jurisdiction is that these entities are entitled to the Due Process Clause protection, so that we would have to establish jurisdiction over them as if any other entity would. We have contended that under the Foreign Sovereign Immunities Act, as a state, if you have service over them, which we have, there's personal jurisdiction. Venue is not an issue because we filed in D.C., which is the default venue against sovereigns under the Foreign Sovereign Immunities Act. So these issues will be briefed through the fall, and as I said, they're in front of Judge Mehta, who's had a couple of cases that are international law cases. He had the McCullough case, which is not directly really on point here. It involved the recognition of an exit award before him, and but it did get him sort of a little bit in the stream of international law issues. He also had an immunities FSIA case prior to ours. So I think the litigation will be interesting. The briefing will certainly be robust as we proceed through the fall. And maybe to kick it back to everyone on the question of why there have been so few lawsuits filed. And a lot of what I do is seeking the recognition of judgments, and particularly against what I would call recalcitrant sovereigns, and getting them to pay. So I'm always optimistic. If I get a judgment, I can recover. And I think many people have been put off by the prospect of trying to recover. But we have moved ahead because we think that we're confident in our case and confident in our ability eventually to recover on it. And I think most fundamentally, this door has been closed since 1996. It's open. We don't know how long it will be open. If there's a change in administration, there could very well be a change in this policy. This administration is certainly not beyond itself to change its own mind about policy, and it could reverse this field, though that seems unlikely, particularly given the fact that a lot of this change one can see as if it is really a way to deal with the Venezuela situation. I mean, some of these changes are as much as lashing out at Venezuela as they are at Cuba, to try to get Cuba, in the administration's view, to stop funding Venezuela. But in any event, with the door open, I think it's sensible to try to get a judgment, because a judgment is good for at least 20 years, and you don't know when you'll have another chance to get one under HelmsBurton.
Thanks, Steve. Steve has really previewed, I think, in a couple of his comments already, one of the important defenses, which really harkens back to the point that David made before, that the important change in the law on personal jurisdiction has really affected, I think, the number of cases and the types of defendants, and therefore which claimants have claims. And so I think that's really been something that back, when we were paying attention to this law back in the 90s, I don't think anybody would have expected that so many of the early defendants would be U.S. persons. I think the expectation, and this is, I think, supported in the legislative history, was really an expectation that this was a law targeting foreign defendants. But we've had change not only in the law of jurisdiction, but in the facts of how much business Americans are allowed to do in Cuba, much more now than was contemplated back then, mainly due to changes during the Obama administration that have been partly but not wholly undone so far. But with this idea of personal jurisdiction is just one of many defenses, and now we really want to turn to Gretel to hear about defenses, and feel free also to pivot into sort of practical advice from the defense point of view.
Sure. I bring sort of a different viewpoint here, because my firm is representing a defendant. Also because I'm Cuban, I grew up there and left the island in my 20s, so apologize for my accent. I have a different view than other panelists here, because I do not like the act personally as a Cuban. But before I go into the defenses, I actually wanted to talk about the question that you just posed of why do you think there's no more lawsuits, especially from certified claimants. And I hadn't thought about this before, but one of the potential reasons that come into mind is that most, for example, for electrical companies' claims, most of the utilities in Cuba, if not all, are really operated by the government, not by foreign companies. And pretty much every sector of the economy is controlled by the government, except for a few areas such as tourism, where
Right.
there are joint ventures with foreign investors, or for example, in the mining industry, where they have some arrangements with like companies, Canadian companies and whatnot. And therefore, I think this is why we're seeing a very specific type of claimant
Right.
coming forward, right? Because otherwise you would have to go against
Doing what we're doing.
exactly the Cuban government, which is it's atypical, right?
Mhm.
In this context, based on the lawsuits that have been filed. In terms of there may also be a wait and see approach, right, to see what happened. But those are my thoughts on that. In terms of defenses, the act. Well, first of all, it's a very new type of litigation for everyone, even for the very experienced litigators. I myself am not a litigator. I'm an OFAC lawyer. I'm a sanctions lawyer, and the Cuban embargo is one of my areas of practice. But what we can tell you in terms of the potential defenses that can be raised in the act, well, in addition to more general defenses that have already been raised by the only defendant that has filed an actual answer to one of these Helms-Burton Act cases is Carnival, and they have raised constitutional defenses like cruel and unusual punishments and lack of due process and that kind of constitutionally based defenses. They have raised a defense on the fact that they believe the lawsuit goes against international law. But there are other potential defenses that are more, let's say, ingrained in the letter and the language of the act. Some of those are, for example, based on the definitions of the various elements or prongs of the act. So, for example, confiscated property does not include, or trafficking, does not include dealings that relate to lawful travel that are necessary for lawful travel. And this is one of the defenses that Carnival has raised and has put as one of its main defenses. You have, for example, the defense that you cannot bring a lawsuit for activities that have ceased 2 years prior to filing the lawsuit. So basically, if I understand this correctly, if you're gonna file a lawsuit today, you have to file for trafficking or activities that did not cease. I mean that were ongoing in 2017, correct? So basically, the window there is small, and there's a place there for conducting discovery and trying to understand, in that window whether that defense would apply. You have also, of course, the limitations in terms of in trafficking as well. The concept of trafficking does not include provision of telecom services to Cuba, and there are foreign companies that have been involved from Italy, I believe, and other countries that have been involved in that kind of activity. That is excluded from the concept of trafficking. Anything that's done by a Cuban national that is also a Cuban resident, even if it involves confiscated property, is also not trafficking. You have, and I'm looking here to see. Oh yes, so for example, if a claimant was eligible for a claim for filing a claim with the Foreign Claims Settlement Commission back in the 70s or in the 2000s, early 2000s, if that claim was not filed, then you're unable now to bring a claim forward. And the same thing, if you brought your claim but the commission denied it, then you're unable to bring it now. There are also limitations in terms of the amount, right? So it has to be about whatever claim you have, because there are certified claims for very small dollar amounts. but your claim has to be at $50,000 or more at the time, which for inflation would be a property of about $400 and something thousand dollars. So we're talking about, properties that have some value at least. It's not everyone, even if you have a certified claim. So there are a little bit of leeways and defenses that are built into the language of the act, and that can be and are being used at least by the one defendant that we have that has filed a response to the complaint, an answer to the complaint. This response, or this answer to the complaint, was preceded by a motion to dismiss, just like the Cubans did. And I think that's probably going to be a position that most defendants will take, right? Let's just file a motion to dismiss first and see what happens. I don't know if any of you is familiar with what happened with Carnival, but when Carnival filed its motion to dismiss, basically it was grounded on three basic arguments or theories. One of them was the lawful travel exception, basically saying that first of all, let me give you some background in the Carnival case, which I believe was the first one to be filed, that was filed on the same day that the act became into effect. So this is the plaintiff in the Carnival case was it's a Cuban descent, and his cousin owned a claim to a dock, or rather a company that owned a dock in Santiago de Cuba, which is an eastern city in the eastern part of the island. And he the ground, or his grounds for indicating that Carnival was trafficking in confiscated property was that Carnival is using that dock to embark and disembark passengers. So that's the extent of the link between Carnival's activities and that property. So Carnival said, number one, because when they engaged in such activities, travel was authorized by the current regulations. It was lawful travel, that embarking and disembarking passengers is it's necessary to the conduct of lawful travel, and they go in their answer in their motion to dismiss to great lengths to say to explain what necessary means, and it's a very interesting read. But the court didn't buy it, so that ground didn't fly with the court, and they also tried to say that shareholders are unable to bring claims for properties of the company that own the right to the property, right? That didn't fly either. So basically, they were unsuccessful in their motion to dismiss, and I think that's for defendants generally, that's a prelude of how other cases may go down in terms of the motion to dismiss stage.
So if I could just interject briefly, I mean, I think it's important to clarify that when you say that they didn't buy it, the defense, I think more technically I would say that they regarded it as premature at the motion to dismiss stage, and
That's right.
it's still going to be considered a valid defense at summary judgment phase. So yes, that has huge impact on the conduct of the litigation, but by no means is it a settled question at this point.
Right, correct. Actually, what they said was that it was an affirmative the lawful travel exception was an affirmative defense, but that the plaintiff was not required to negate the affirmative defense in the complaint. But it does tell you a little bit of what to expect when bringing these defenses that are ingrained in the language of the act. In terms of practice or practical issues, I think, and this is something that other panelists have not discussed, but I think there are issues that are common to both plaintiffs and defendants. Of course, we're talking in many cases about, well, in most cases, issues that happen or facts that happened more than half a century ago. So in terms of records to prove ownership, if you don't have a certified claim, in terms of for example, Cuban law that can be relevant to determining some of these issues or to make arguments for some of these issues. There's a challenge there. If you have to conduct any discovery in Cuba, especially for plaintiffs, I think it's going to be challenging. But I think likewise for defendants, I think the other issue with the act is that you don't have precedent, right? So basically you have no plaintiffs, both plaintiffs and defendants have very little to go by in terms of anticipating or determining what their litigation strategy is going to be. I think from a defendant standpoint, something that we're seeing, the potential certification of class actions, the joinder of many defendants with different types of claims in different claims to different types of properties. It's also challenging from a defendant standpoint. I mean, it is it makes it more complex for both defendants and plaintiffs, but that's something also that's happening now that seems to make it more difficult. I don't know if others.
Well, thanks. I think we definitely want to hear from others about practicalities. And one thing, in particular, I'd appreciate if you address Steve already made the point that they wanted to file quickly because of the possibility that this might go away. So as a practicality, when you're dealing with the problems of bringing a case in the right way, to what extent are you keeping an eye on and how are you managing the risks that the right to bring these lawsuits might be suspended at some point in the future?
We have about 12 families that we work with, and they're all certified claims. And we've been working on claims since the early 2000s. And while I can't speak for any of my clients, I can tell you that in engagements with policymakers in the Obama administration, the Congress, and now with the Trump administration, the goal's always been to find a way to settle claims. The goal's not to litigate. And having a certified claimant have to go back into court on a trafficking issue. And these cases are not easy to make. And let's give you some practical points. For example, there's a question, and we've asked for guidance from OFAC on this. Can I send investigators to Cuba to help me figure out who's on the land? Do I need an OFAC license for that before I file the case or not? There's little and there are people who do it, and we know companies that do it. But there's an ambiguity there that I would be cautious when advising anyone considering doing something like that. The second issue is, well, who are you going to work with in Cuba? The independent practice of law in Cuba is unlawful. It's illegal. All the lawyers work for what are called bureau colectivos. They're state lawyers. You can't go off and hire an independent lawyer in Cuba to advise you on a Helms-Burton case because they may go to jail for doing that. In fact, most independent lawyers would not touch a Helms-Burton case. And some of the lawyers I know who work for bureau colectivos will not touch Helms-Burton cases. A very small group of lawyers that can do that. So there's some challenges there about getting accurate advice about what's legal, what's not in Cuba right now when it comes to property. Then there's the issue of the property registries in Cuba. You just cannot walk up to a property registry and pick up a record. That's not the way it works. And there's a question of which record is the accurate record. So they're not easy cases to make, even if you're a certified claimant. Most certified claimants, again, that we've interacted with throughout the years, and some that have testified in Congress about this, are very clear. They want settlement. And they do not want to have to go in there because some of them view these as, I already have a piece of paper. By the way, the Treasury says I cannot sell, that I cannot transfer. And there's a 2008 guidance that I point you to that was published by the Treasury Department, I believe it was July of 2008, that takes the position that a certified claim is a property in which Cuba or Cuban national has an interest. And you need to go to OFAC in most cases to, let's say, transact in that piece of paper. And I say we've applied for licenses and we've been rejected multiple times. on coming up with different solutions about how we can potentially come to settlement on some of these certified claims, and they've been rejected. This is pre-Helms-Burton, of course. And just one quick final practical point on Helms-Burton. I hope that the Trump administration, now that they've opened this potential Pandora's box, realizes that it just cannot focus on the courts. It has obligations now to follow through on policy to try and bring Cuba to the negotiating table. Whether the Obama administration did this the right way or not, they did bring Cuba to talk about claims at least 2 or 3 times. I think that's important. We filed the Freedom of Information Act in 2014 and one 2015. Unfortunately, we're now litigating in district court here in DC against the State Department because we're trying to get more information on that process, and we are going to eventually publish what we recovered from that, was produced from that. But there were some things that happened in 2014 and 2016 that we think the general public should know about, and that will, I think, impact some of this litigation. But we think the Trump administration, though, has to continue, and it's just not letting the court let us into the courthouse. They need to enforce Helms-Burton that has never really been fully enforced. The same thing with the Cuban Democracy Act. If the goal is to settle the claims, they just want to have us in court for many years and have us argue all these nuances of law, which we all enjoy talking about. That's fine. That's not going to bring us to closure on claim, and Cuba can settle the claim if they wanted to.
So,
Please, about 5 minutes maybe
Okay.
on practical thoughts.
well, let me come back just with a question, because you've raised, I think, an important issue, and I want to make sure that we clarify for me and perhaps for others. You said you'd gone to OFAC to get a license, and I would distinguish between a license to transfer a claim and a license to settle a claim. And I understand that OFAC is rejecting license applications to transfer claims for value, and there are reasons for that. Have you had OFAC reject a license request just to settle a claim? I would think the answer to that would be no, but if OFAC is rejecting that would be that'd be an important point.
No, that hasn't happened.
Okay, just checking.
Although we've tried to come up with different and, let's say, innovative private solutions to a certified claims process, which have been rejected because
Sure.
they conflict with the sanctions.
Right.
And that of course makes a whole lot of sense. One more point about certified claims, by the way, there is a statute that prohibits speculation in the claim. So if the claim is worth $1 million, you can't go out and try and get more than the face value of the claim, which is just one legal point that I think OFAC and State Department both struggle with that, because if we wanted to create a private sector, a real, genuine private sector solution to something, let's say you want to create a claims fund, and several lawyers have tried to do this over the years, create claims fund to try and pool the funds and try and see if they can monetize them and transact in them and have a process where the claimants can have their settlement and then you have a pool of claims. That has been a source of somewhat of the licensing uncertainty and friction about whether or not you can even do that.
So let's just be clear for the audience. There are 2 different statutes and legal regimes at play here. There's what I call an anti-arbitrage statute. I don't have the numbers. If you contact me, I'll give you the statute. But it basically says that you cannot, if you transfer a claim for value, a certified claim for value, it becomes worth what you pay for it. So if you have a claim for $100 million and you sell it for $1 million, that claim is now worth $1 million. The idea of this, of course, is to deny people the ability to aggregate claims in order to create a secondary market. That is separate from a separate legal concept that says that a claim against Cuba is somehow a blocked property in which Cuba has an interest that you therefore cannot transact business with because it's effectively Cuban radioactive. You can't touch it, but for provisions of Helms-Burton that say that you can bring a claim on those claims and you can settle a claim on those claims. And we have seen, for example, settlement of claims under Title IV,
That's right.
right?
Yeah.
STAT, ITT, Grupo Domo,
Right, yeah.
a variety of those claims. To the best of my knowledge, everybody who settled those claims, none of them were prosecuted by OFAC. None of them were prosecuted by the Department of Justice. There were no warning letters or claims that those settlements violated anything.
But OFAC was involved in the ITT step. They were part of that process. So
Correct, but I don't believe that there was ever a license issued
I don't know.
to permit that.
I don't know.
If anyone's aware, that would be interesting news. But there were other Title IV settlements as well.
Yeah.
And so I don't think any of that has ever raised an issue. And I think arguably that might conflict with at least the spirit and purpose of HelmsBurton.
Under the face of the statute, I don't think OFAC has the authority to stop a settlement, so I wouldn't think a license would be needed.
Well, I think just take a look at the 2008 guidance, because they view the claims as property in which Cuba or Cuban national has an interest.
Yes.
So transacting, and that's broadly defined, the Trading with the Enemy Act and some other rules, and they take a position that I would counsel a client to seek guidance at minimum before engaging in final settlement, not outside of Helms-Burton. Helms-Burton is very curious. When you file a Title III case, you have a general license to engage in you have a lot of freedom after you file your case. And there is a general license in the statute. And you have a lot of leeway. But you don't have that leeway until you file a lawsuit. And if you read that 2008 guidance, we take a very cautious view about transferring that paper without some type of guidance from the U.S. government that what you're doing is not violating the sanctions.
All right, thank you. So it's time to bring in comments and questions from the audience. If there are none, we can just continue. We have a question. There we go. And please stand up and say who you are.
Sure, Bethany Cowan, Maker House. I was confused by, first of all, the presentations were fabulous.
Thanks.
I was confused by, this is not my area. Stephen, you said you don't have to be a certified claimant to bring a case. But Gretel, you said if you were eligible to bring a claim and didn't, that's a bar. I'm trying to figure out what the disconnect is and how to reconcile those two things.
That's right. That's just the language of the statute. I'm not sure it's true.
But if you have a claim, but you didn't go through the Claims Commission in 1970, but you're otherwise eligible to bring a claim, you still can.
So in a nutshell, Americans who had their property taken when they were Americans had to go through the claims process and become a certified claimant. And if they didn't go through that process, then they basically waived their rights and can no longer proceed as a non-certified claimant. But people who were Cubans at the time their property was confiscated were not eligible for that claims process in the past. And the Helms-Burton Act has, for the first time, created a process. And so those are the non-certified claimants at this point.
Right.
Other questions or comments? I think I see a hand.
Hi, my name is Eric Fellon. I'm the recent law school grad that works as a firm here. Some of our clients have been curious about the lawful travel exception, particularly in the transportation space. Does anybody have any idea where that's going, or is that just because they haven't accepted those motions to dismiss? It's basically just a signal that this is very up in the air.
I would think it's pretty. I mean, there is an exception in the act, and I don't think it just as Perry was saying earlier. I don't think the courts have yet said, that the particular fact pattern that we have at this point, which is the Carnival fact pattern, right, embarking and disembarking passengers in a dock. We still don't know if the court is going to find that exception applies or not to that particular fact pattern, but it is expressly included as one of the exceptions to the concept of trafficking. And therefore, I don't think what we have thus far is enough to say we have a precedent or anything. It's simply the court basically said, we're not going to talk about this now. The plaintiff is not required to, negate the defense in the four corners of the complaint. So it basically hasn't been really litigated.
Although I think the judges down there in Miami kind of punted on this. And I think the statute says if you have lawful trafficking, you can't be liable. And he went through a lot of sort of, is it an affirmative defense? Is it a question of fact? And I think I'd be surprised if the court of the 11th Circuit came out the same way. And I mean, he still has a summary judgment motion. You know, he allowed discovery to go forward, but I mean, who knows? But I think it's a pretty strong defense.
So I think there are three issues that you need to think about. The first is back in 1996 when the statute became law, what was lawful travel meant one thing. What happened during the Obama administration, creating 12 categories of travel that were lawful, is a different thing. And then third, the question of whether or not, for example, a cruise ship is carrying non-tourists down to Cuba in order to only engage in 12 categories of lawful travel, and whether or not any of those individual individual passengers on those ships were all engaged in lawful travel, I think is a separate question. And I think that's what the courts will be grappling with.
Yeah, and I think that's something that one of the more heavily litigated parts of HelmsBurton, I think, will be there, because I've never practically, not legally, never seen the difference between an airplane and a boat carrying people to Cuba. That's travel. There's been particular reasons why, which we don't have time to get into, why the boats were excluded, but I'd be hard pressed to see a company like Carnival or some of the others engage in that type of travel if they didn't have some type of either a general authorization or some type of a specific license to engage in that type of activity. That's probably going to be the strongest defense. Those 12 categories may have been outside the scope of Helms-Burton, but I'd be surprised if judges are going to start reading into what President Obama meant by that. The courts tend to avoid trying to second guess the executive on national security and foreign policy issues. I tend to think that we've cobbled so much into Helms-Burton about what's travel and what isn't, that it's murky and it's going to be sorted out through the courts. I don't think it should have been, but that's where we are. But incident to lawful travel, telecommunications are very clear exceptions in the statute. And I think that's going to be probably the strongest defense moving forward.
Yeah, I mean, I think there's really an awful lot in this travel exception, probably because travel is so important to the politics and the economics of the Cuba embargo, and then the changes that Obama made and the changes that Trump have made have really been very centered on travel in a way that I think has given rise to some unexpected results when you look at the lawsuits now. Again, we said that a lot of Americans are being sued, and in particular, it's American businesses in the travel industry that I think not only was not expected in '96, but really Congress legislated to explicitly take that off the table. But I think probably having in mind, as David said, a very much more narrow scope of who would be covered by it.
Yeah, I mean, travel to Cuba is what oil is to Iran. I mean, it's their main moneymaker. So obviously it will be targeted. And if whether we agree or disagree with the other elements of Helms-Burton, like Title I, I personally don't believe you can export democracy. And it's always been an issue that I've had with Helms-Burton and with the Cuban Democracy Act. You've cobbled so much into that, and you've conflated so many policy issues into that. But ultimately, that's the nub. That's the heart of Helms-Burton, is the travel. Because if you're trying to impose maximum pressure on Cuba, that's the sector you will target, travel. Because that's one of their main money makers. Although ironically, their main money maker today is remittances. They bring in about $4 billion plus a year in remittances from the exile community and from the diaspora. So it's not necessarily travel anymore. It's travel by Cuban Americans to Cuba and remittances, not necessarily the tourist sector. But I do think that's naturally going to be, which is when I mentioned earlier, the Trump administration will have to enforce Helms-Burton. You need, if you want to bring Cuba to the negotiating table, if that's the goal, you're going to have to do a lot more than haul them into court.
One of the other things that I think is interesting about the travel issues. I'm losing my train of thought. I'm sorry. I'm sorry. I saw a hand go up and I got distracted. I'll just turn over the floor, please.
Sorry.
No worries.
Dick Fury, Baron Fox. We haven't said much about Title IV tonight, but I was wondering if the panel had any thoughts on potential, let's say, inconsistencies when you have Title IV and Title III in action at the same time with the same party. So on one hand, you've got the State Department making a determination of trafficking, and for the same entity, you may have, you have a court making the same determination. Any thoughts on that conundrum?
So at least from the claimant side of the prism, until there is, because you don't find or hear from the State Department negative determinations about trafficking, the only thing I think you will see are affirmative determinations that a company is engaging in trafficking and is going to be denied visas under Title IV that will be beneficial to claimants. But as far as I know, there's no whitelist or blacklist coming out of the State Department for entities that have been determined not to be trafficking, such that you would have any kind of violation. Remember that, you know, the Helms-Burton desk, such as it is, that was at the State Department for the last 20 some odd years, was fairly highly staffed, and then it diminished over time, and now there is evidence of some resurgence of interest and effort by the State Department to start to utilize Title IV, which I think is consistent with bringing lawsuits and claims under Title III, the goal being to encourage settlement and resolution of these claims. It seems to me if an entity were to try to resolve a Title IV issue, as long as they're speaking to the claimant, they really ought to try and resolve Title III at the same time.
Well, I'm really focusing on it from a legal perspective, not so much policy and what you might do in negotiations and things like that. Assume, I mean, the State Department is making a determination that they're going to revoke, there is trafficking according to them, and then you've got a competing judge wrestling with the same issue.
I think it is possible that you would get anything is possible, right? That State Department could issue a visa ban under Title IV, and a judge might find that there is not trafficking under Title III. Unless and until we get there, I'm not sure that that's. It's a theoretical issue that I think is real, but until it happens, yeah, it's not something I'm particularly worried about.
So it's time to wrap up, and I don't know if maybe starting with Steve and coming down the table this way, if anybody wants to talk for maybe 1 minute, some closing comment, final observation, anything like that.
Sure. I think there was a lot of discussion about the ability and the efficacy of trying to settle these cases as perhaps the best way out. I think now that we've sort of unleashed the litigation, I think we're going to have to see how the cases play out a little bit before there's more serious settlement negotiations. I mean, our clients were involved in some of those discussions back then as well, and had decided once the window opened that the best way to try to get money is to try to get a judgment. And I think we'll see how that plays out, but I think that's the next step in this drama.
I suppose from my perspective, being Cuban, having protested the act as a 10-year-old or 12-year-old back in 1996, I think the act is excessive and not proportional. There's really, and I was discussing this with other people before, there's really no correlation between the amount of the claim and whatever damage has been caused by the defendant to the plaintiff. Actually, some of these defendants have actually added value to those properties by developing infrastructure in those properties, for example. And it's also not proportional to whatever benefit the plaintiffs are getting from the trafficking. You have companies such as Amazon that's being sued for marketing charcoal that was produced or in a confiscated land. So there's, in terms of proportionality, it's really out of this world, I think. And from a Cuban perspective, I think about 94% of the people in Cuba today were children in 1959, 1960, 1961, and have no part in whatever happened back then. In a way, the Helms-Burton Act and the effects, the chilling effect that the Helms-Burton Act may have in foreign investment, in foreign activity in Cuba. It's ultimately sort of a punishment to the Cuban people as well. So when looking at these acts, there are victims maybe that are the former owners of these properties, and now whoever owns those claims, but the Cuban people is also a victim here. So just wanted to throw that out there.
I think if this process puts in motion a new phase in U.S.-Cuba relations that leads to negotiations with Cuba on the settling of claims, I think that's a net positive. I think there's a long-standing tradition in the United States of defending property rights. I mean, we have a very rich history dating back to the 1930s and 40s of claims processes, and we successfully have negotiated claims programs with Vietnam and many other countries, the ex-Soviet Union, and Cuba for some reason has been the lone holdout for whatever reason. If this is what it takes to bring a settlement to this process and have respect to property rights, again, how we settle the Cuba program, I say this a lot, I think will impact long-term in other countries and how we interact, and it telegraphs to the market that sooner or later the United States will stand up for their nationals and seek justice. And I think that's one important takeaway. The Nazi Holocaust cases, for example, are still ongoing. I can't believe there's legislation in Congress right now to try and deal with some of the old Holocaust cases on insurance claims, and there's bills in Congress to deal with that. There's no reason for that. I think we have a process here in place that builds on some of the victories of prior people who've come and gone through these difficult processes. And as far as certified claimants go, it's a fixed dollar amount. Cuba knows how much it is. It claims it wants to settle. These lawsuits and this process can be tempered if they were just to take a step back and settle the claims.
Claims to confiscated Cuban property and the Cuban embargo have been in place for almost 60 years. Resolution of those claims, resolution of the embargo, normalization of relations still escapes us. We have tried over the decades any number of ways to try and resolve these claims and the embargo and the problems between our nations multiple times. What we have seen since May, at least in my own experience, is a new opportunity to engage in dialogue and settlement talks that are ongoing. There are confidential settlement negotiations happening between claimants and defendants and Helms-Burton related claims that are ongoing, I can tell you that. The Cubans are opening up negotiations and discussions with claimants, certified claimants, non-certified claimants, claimants of a certain size. There is a new energy and new opportunity to try and resolve the differences between us. Whether those claims can be resolved, whether the window that has been opened for resolution by Helms-Burton and the impetus for bringing these claims will actually come true, it's hard to say. Whether the new secondary embargo that the opening of Helms-Burton in Title III has had on new investment into the island, which I think has had a tremendous chilling effect, frankly, will help to encourage resolution of those claims. It certainly has gotten Cuba's attention. It's certainly gotten the attention of the companies that are doing business with Cuba. Those companies are now concerned about these claims. Those discussions are ongoing, but they are happening, and we are having them. This is real. Whether or not it will lead to resolution, whether or not this will be yet another failed attempt, I think that remains to be seen. But it is a new beginning, and it is a new opportunity. It's good business for lawyers, I'm not going to lie. But it is really happening, and it has created a new opportunity. And I think what we choose to do and how we choose to approach this and what we choose to do with it, we'll see whether or not this isn't actually an opportunity to bring this long-running disputes to an end and to help everybody move forward in new chapters.
Well, I'd just like to thank our panel. It's been a very strong and interesting panel. We've heard about events since 1959. We heard about a a motion that was filed a few days ago. And I think this is really just the beginning of an ongoing discussion of what's really going to be an important issue as these cases unfold and new cases come and diplomatic controversies come having to do with all of this. And it'll be very interesting to see how it all plays out. So I'd like to thank the four of you, and I hope everybody will please join us.